Welcome to Expert Views on ADR Ever, a podcast about simplifying the traditional African method of settling disputes or the appropriate dispute resolution ADR in a bid to attract more users to settle their disputes or conflicts with mediation, arbitration, collaborative law, restorative justice, negotiation, conciliation, and of course, early neutral evaluation. My name is DrChinweEgbunike, a postdoctoral fellow at the University of Brighton, United Kingdom, and a fellow of the American Bar Association section of dispute resolution. I am excited to welcome Laurel Stevenson to the EVA show. She is the director at the Mediation and Assessment Program MAP. Before joining the court, Laurel was a litigator for more than 2 decades, a facilitator for the Missouri Bar Complaint Resolution Program and Fee Disputes Resolution Program, a mediator and arbitrator. In 2023, she was selected as a fellow of the American Bar Association section of dispute resolution and serves on Court ADR Committee. She wears many hats, so I've left the links to her profile below. Welcome to the show, Laura. Let me stop sharing now.
Thank you so much, Chinwe.
Such an honor having you.
Thank
you. So without further ado, the first question is, what is the Mediation and Assessment Program MAP?
So, yes, because of the length of the name, it is frequently referred to as MAP. And what it is it in the Western District, which is based in Kansas City, but we also have courts in Jefferson City, Missouri, and Springfield, Missouri. And it is a program to facilitate the early resolution of disputes. All of the matters that we see are matters in litigation. And so those cases, primarily civil cases, are assigned to the program early on. And then there's also a provision if those cases don't resolve early on for those cases to go back to what we now call later stage dispute resolution.
Oh, okay. Thank you so very much. So is it a court-connected ADR center?
It is, yes. So I am, of course, the director. I'm an employee of the court, and then I have 2 staff who help to administer the program within the court.
Oh, okay. But you just settle civil cases, not yet criminal cases?
No, we have been looking at that. There are some courts that do provide for dispute resolution in criminal cases, but in part just because of the magnitude of the cases that we have in our program. We also have a number in our program that are multi-district litigation, or what people more frequently refer to as MDLs. And so just navigating through those is a very time-consuming task, but we certainly do recognize the importance of utilizing dispute resolution in the criminal case context, and that is something we are continuing to evaluate and may at some point look at administering.
Oh, okay. So due to high volume of cases, not yet administering criminal cases yet. Okay, thank you so very much for that. So why was it created, and to what extent has ADR, particularly mediation, enhanced access to justice in the US?
So originally, Congress passed what was referred to as a pilot program for the use of dispute resolution in the federal courts because the courts were getting really backlogged. Cases weren't moving through the process quickly enough. And that, of course, was providing some significant impediments to access to justice. So a pilot program was created. The Western District, actually in Kansas City, was one of 5 pilots or 5 programs in the pilot. And then after that pilot program, Congress then mandated dispute resolution within the federal courts. And then eventually that led to what's referred to as the ADR Act of 1998, And so all federal courts are required to have available at least one form of dispute resolution to the parties for civil cases.
Okay. Okay. So, to what extent has it enhanced access to justice so far?
Well, I would say based on, I mean, we have very detailed statistics for the last 10 years. We actually have statistics from the beginning of the program, but in terms of the level of detail that we now have available, we feel solidly that 10 years of data is very strong and indicates that party involvement occurs much earlier on in cases because the parties are required to go to a form of early dispute resolution within what we call 75 days of the Rule 26 conference. So when the parties are discussing a scheduling plan and discovery, and the parties themselves actually have to be directly involved in the dispute resolution process. This isn't a matter where attorneys can just do it on their own without client involvement. And that's true whether it's mediation or any other form of dispute resolution that we have under our program.
Okay. All right. Thank you so very much, Laura. So compared to litigation, how far has sorry, when it comes to costs and time frame, is there any measurable difference between litigation and settling cases via litigation and mediation?
Yes, so we actually do, excuse me, a number of surveys throughout the year to sample cases and get feedback from counsel and even from pro se litigants, those who are representing themselves, because we do have a number of them as well. Now, they, of course, aren't as familiar with the process, so it's difficult for them to provide a true cost assessment. But in the what I would call the less complex cases, those cases that maybe have just one or two counts in the complaint, the average savings is about $25,000. And in the more complex cases, I can't really say that there is an average, but I would say on average, the feedback that we receive is that the cost savings is anywhere from 80 to 100,000 and upwards from there.
That's a lot of money.
Yeah, we've had, and I apologize, we've had some that are upwards of $300,000 to $500,000 in savings.
Wow. Oh, so that's great. So when you compare it to litigation, you save more money via mediation. Okay. How about the time frame?
So our particular program requires the parties to go to a form of dispute resolution, and mediation is the most common form. But we do have a number of other forms of dispute resolution, including, and you had mentioned at the outset, early neutral evaluation. And that is something that we've utilized. We've moved that now more towards what we call neutral evaluation, which has the same components as an early neutral evaluation, but we moved it to neutral evaluation because the guide to judiciary policy was updated last year, and the thought process was to allow the parties to utilize that form of process sometimes later. But certainly early is what we really strive for. And so that is a specific time frame is 75 days, within 75 days of the Rule 26 conference. So what that usually means, and it just depends on case filing and then the actual assignment, but it usually means that parties are coming to the table for mediation, particularly within about 3 to 4 months
Oh,
after the lawsuit is filed.
mm. Oh, okay. 4 months. Okay. Mm. Okay, thank you so very much. So that compared to litigation, it's way faster. Yeah. Okay.
It
Thank
is. And, because litigation, as probably many people have experienced, I mean, it can go on for months, if not years. I
you.
mean,
Yes.
there have been cases that have been 3, 4, 5, even upwards of 10 years in the process. Not so much anymore in federal courts, just because there are also a number of other mechanisms
Oh,
designed to
okay.
expedite, but certainly, there are still those cases out there that can take many years to work through the litigation process.
Oh, okay. Thank you so very much. So how does one initiate a mediation with MAP?
So the way that our particular program works is that when civil cases are originally filed, the clerk's office randomly assigns those cases to MAP. And the default is to mediation, just so we make sure everybody has a specific assignment.
Okay.
Then, depending on what category they're assigned to, so in our court, we have 3 primary categories for those random assignments. The cases either get assigned to me, they get assigned to a bankruptcy or magistrate judge, or they get assigned to what we call our outside neutral, what had been our list of mediators, but now we call it our outside neutral list, just because if parties choose a different form of dispute resolution aside from mediation, they can contact me to talk to me about that choice, and then I can allow them to engage in some other form of dispute resolution besides mediation, but that still is required to be done within 75 days of the Rule 26 conference, unless there are reasons to put that out a little bit further.
Oh, okay. Thank you. So have there been recent changes to the court panel of neutrals that might provide insights to other courts interested in having neutral panels or making changes to their existing panels?
Yes, so in fact, tomorrow we have a new list of neutrals,
Oh,
and it actually is 2 lists. So we have what is called the Category 1 list, which essentially is replacing our current list of what we call our list of mediators. And then we have a Category 2 list, which is a smaller list. It's maintained internally by our office. That list required those applicants to go through a more detailed application process. They had to also go through a specific selection committee
okay.
that included a district judge. Because since I'm making the assignments, we want to be as transparent as we possibly can in those assignments. And so we looked at a number of different competencies for those individuals and to place them on the list. So, and even with updating our current list of what we now call the Category 1 list of neutrals, we wanted to get some further input on the background of individuals, because while certainly the importance of training in mediation and dispute resolution cannot be understated, having individuals who have broader interests, perspectives, backgrounds, competencies, everything from cultural competency to experience with different types of groups, to experience with particular types of policy issues, legislative issues. We've really explored how important that is to parties in helping them in trying to resolve their disputes. So that's probably more of an answer than what you needed, but we took into account a number of factors
Yeah.
that we felt are important to the parties.
Okay. All right. Was there any like interviews with the parties?
We did.
Yeah. Okay.
Now, because of the confidentiality in our program, the way that we did that typically is if I received, and this was a process that was about a 2+ year process in the making. And so as I might get a party that may contact me when they're assigned to the program, or they might contact me after
Yeah.
they've gone through a mediation or neutral evaluation, then what I would do is I would say, provide me with your feedback. What was your assessment of the situation? How did you feel that the neutral handled the situation? Were there other things that you would like to see? And so we collected all of that information, and we had some of our outside neutrals that did the same. They would do some follow-up outreach. Some of our magistrate and bankruptcy judges did the same. And so we compiled all of that information and then making a determination as to what path we were going to adopt going forward.
Oh, okay. Thank you so very much. So that leads to the next question, which is how safe are confidential data for both the parties and the mediators?
Well,
and how does MAP handle cybersecurity? Sorry about that.
No, and I apologize for interrupting. So confidentiality is really the key to our program, especially when it comes to mediation in particular. And one of the reasons for that is because of the model standards of conduct for mediators, ensuring a quality of the process, and the fact that I am the person who administers the program. So even though I am a court employee, I pretty much handle things just like an outside neutral would. Yeah. So I'm not allowed to go to the court and say, well, this is what the parties did or said, or all of these things. So we have that built into what we call the general order that is what the court on bank adopted for the administration of MAP. And we provide ongoing training and instruction on confidentiality. We also have guidelines for virtual mediation and virtual dispute resolution, making very clear that only certain platforms should be used, because unfortunately there are those platforms out there that are not secure. And so fortunately other than very early, which probably everybody experienced in the pandemic, unfortunately in 2020, since we have made very clear the platforms and how we treat cybersecurity, I've only become aware of 2 situations where there was a potential breach. And fortunately, the potential brief was not that it was insignificant, it's always very significant to look at, but it was insignificant ultimately in that there wasn't any disclosure of confidential information. The people involved took the necessary steps once the issue was encountered, made sure that everybody was secure, and then did the necessary testing before the process proceeded to make sure that there wasn't any kind of infiltration on the confidential nature of the process. So I think it's worked really well.
Oh, that's great. Okay, so the final question is how has MAP worked to increase diversity amongst its panelists?
So, yes, and so one of the things that we have looked at is, we've had a lot of people who've been involved in the program really since the outset. And so we have called on them to really encourage them to have individuals shadow them, individuals not only in law school, but also individuals in college or even high school.
Oh,
We
great.
feel that reaching out even earlier to allow people an understanding of the process, getting involved in various groups that high schools and colleges and universities have to identify different types of groups and different types of interests, and having our neutrals bring individuals from those groups into shadow, and also encouraging those neutrals to go out and talk with those groups about what they do so that we can get them involved and interested early in the process, because there had been sort of this stereotype that, well, the only individuals who can do the kind of work that is done through the MAP program, through the neutrals, are, people who've been out 20, 30 years, have this particular path. And what we have found is, certainly while those individuals do really good work, there are a lot of younger individuals,
Okay.
and with a lot of varied interests,
Yeah.
that can provide an excellent benefit to our program. So that is something we're continuing to focus on and really emphasize, because really we feel like that's the next generation of individuals. And frankly, for somebody like me who's been out for 34 years, it's important for me to be exposed to those different individuals.
Yeah.
And I think I mentioned early on cultural competency.
Yes,
That's something that is very significant. I mean, how we use language, words, how people respond to certain things in a dispute is going to vary depending on what their backgrounds are, how they were raised, any number of things. So it's really important, for me as well, to have a better understanding, to be involved, and to continue to work with a number of different individuals.
Oh, thank you so very much, Laura, for giving us, offering a detailed overview of how MAP works. This is the first time I'm hearing about, the components and intricacies associated with MAP. So it's I thank you so very much, and I commend you for coming on the show to really discuss how it works. So for those people that are yet to utilize ADR, particularly mediation, they can know that the center exists and walk into the center, or via virtual program which MAP offers as well. So thank you so very much for your insights and perspective and learning that you shared with us. I believe that potential users would embrace all the benefits associated with ADR that you mentioned here and opt for it whenever the need arises. Thank you for coming on the show.
Thank you so much, Chinwe. I really appreciate your interest and the opportunity, and happy to answer any questions that anybody may have in the future. Thanks again. It's been a pleasure.
Same here. All right. Bye. Take care.
Bye.
Cheers.
Thank you.
Bye.